Colin O'Keefe here for LXBN TV. Thanks to a ruling coming out of the Southern District of New York, Google has scored a major victory, as it was ruled their Google Books product constitutes fair use of copyrighted materials. To explain the ruling and its impact, we bring in Chicago attorney Evan Brown of Info Law Group. He recently covered the topic on their Info Law Group blog. Evan, first, let's run through the basics. Can you tell us about the background of the case and how the court arrived at its decision?
Sure thing, Colin. Great to be here and looking forward to talking with you. This case has been going on for about 8 years. It was all the way back in 2005 that the Authors Guild and some authors filed suit against Google. It's a copyright infringement matter, and what Google did was undertake this very ambitious project of digitally scanning literally millions of books and indexing that material, making it available for search, and putting that on the web so that people could run a search for a particular term and find snippets of those particular books and learn more about those books, and it was a great aid to research. So the case was filed in 2005, and in 2008, already 3 years into the litigation, the parties came to a settlement agreement. And through some different maneuvering there, the court rejected the settlement agreement. This was in the Southern District of New York. Later, just more recently, within the past year, the Second Circuit found or held that it wasn't proper for this to be a class action lawsuit. So we were beginning to see some signs that this was going to go better for Google and not so well for the Authors Guild. The recent decision from the district court level held that Google's efforts to scan these works, these millions of books, and make them available for search was a non-infringing fair use, which is an affirmative defense to copyright infringement. So it's that fair use determination that really is the most interesting about the decision here, and which was giving us plenty of things to talk about.
Absolutely. So second, what does this ruling say about innovation in general and the laws that govern it? What does the ruling mean for other so-called technology disruptors like Google Books?
Sure. It's a positive ruling for the side of innovation, because what we have here is the traditional application of copyright law, because what was going on by making the copies of these works, it was an infringement of copyright. The court found that indeed there was copyright infringement going on here, but Google's efforts and the technology that it chose to employ by doing these things was protected as a fair use. So what we see here, what the result is the court finds that there is room for innovation. It's a very well-balanced decision, and that is indeed what the doctrine of fair use is intended to do in copyright law, to sort of serve as a backstop against over-aggressive copyright enforcement. Again, if we back all the way up, the whole purpose of copyright law, going back to the Founding Fathers, is to promote the progress of the arts and science. So there is room within the doctrine, or within the body of copyright law, brought forth with this doctrine of fair use for innovation to take place, even though it actually technically is a copyright infringement. There is this space for new technologies to come in and do innovative things like what we've seen Google do here in this situation for the past decade.
Absolutely. It's both interesting and positive to see the courts reward innovation like this. Once again, that was Evan Brown of Info Law Group. For more of his insight on this case and others, be sure to visit infolawgroup.com. And of course, for more video interviews with attorneys like Evan, along with curated commentary from the LexBlog Network's more than 8,000 members, be sure to visit us at lxbn.com. Thank you for joining me today, Evan.
Thank you, Colin. My pleasure.